We're going to talk in this session about legal parenthood, or the conundrum we have for Australians. And we're really lucky. We've got two expert lawyers here to help us with that. Monica Blizzard from here in Australia. She's a family law specialist down in Victoria and has got a lot of expertise in surrogacy matters. She's been coming to our events for years. She takes a pretty holistic approach to this kind of stuff, and she often brings in psychologists and family report writers to ensure journeys through family law is both efficient and cost effective. We've also got Dana here, who's an Israeli lawyer practicing since 2003. She specialises in surrogacy and ART, and she's the founder and legal advisor with Lotus, who you've heard from already this weekend. She's handled legal aspects for about 200 cases of surrogacy for foreigners going to different countries. India, I think, Nepal, Ukraine, probably more now, over about 12 years. So she's got lots of experience in the legal issues there too. So we're going to focus on some of the conundrums for people using Australian surrogacy and offshore. I might start with you, Monica. What I want to know about is, for those using Australian surrogacy, how do they achieve legal parentage here?
So Ben touched on the legal framework earlier today, and so I'll just go into that in a bit more detail, but there are different laws in each state, so it's important that you do look at that. I would practice in Victoria. The general approach is there's a birth certificate issued in the state where the baby is born, and in Victoria you can apply for a substituted parentage order.
So just that birth certificate is issued, is it given to you? The birth certificate actually physically given, here's your birth certificate?
Well, I'm trying to think back when. So the birth certificate, you apply for it when the baby is born, and then it's sent to you. Yes.
And whose name is on that first birth certificate?
So that's the important thing. So under the Family Law Act, there's a presumption around the legal parent, and that presumption is that the surrogate and their partner is the legal parent, and they're named on the birth certificate. So the person who gives birth is effectively the legal parent initially.
Right. So how long does it take for a new birth certificate to be issued with the intended parents' names on it?
So the substituted parentage order process, as I said, it does vary slightly from state to state. In Victoria, I had a surrogacy arrangement where the baby was born around Christmas last year, and the application was made in February, and it was granted within 3 months. So the order was processed through the county court, and subsequently the birth certificate should be expected any time now.
I hear many cases where it may take 12 months for this to happen. Have you seen cases like that where it can take 12 months for that process to happen?
That hasn't been my experience, but speaking to other surrogacy lawyers, it has been. Yeah, right. It really does depend on the courts. One thing we don't have control over as lawyers is how quickly courts process things or list things. There can be complications, obviously, unforeseen circumstances.
Right. So from a practical point of view, what about Medicare for the child? Does the child go on the surrogate's Medicare card then to start with, or the...
So the issue is, certainly in Victoria, you can't apply for a parentage order in a domestic surrogacy arrangement. The baby has to be, after about 28 days and before 6 months is when you make your application. So there is that gap there where if something was to go wrong, technically the surrogate would be making the medical decisions. That changes once the substituted parentage order is granted, and then things flow from there.
So in that first 3 to 12 months where the surrogate is the legal parent, how can the commissioning parents make key decisions, admit their kids to hospital and so forth for that child?
Yeah, well, it's a difficult situation. It's exactly a conundrum. So the legal rights rest with the surrogate and their partner. Our advice when advising people going through surrogacy arrangements is, even though it's not legally enforceable, is to enter into a surrogacy agreement, and that would deal with how do we make the medical decisions, what are the boundaries of that relationship. Most of my clients would make all the medical decisions throughout the pregnancy together, and so technically, you'd think it would be done in consultation between them, and that would be the intention for most surrogate couples and surrogacy arrangements. But if there was a dispute between them as to the type of medical treatment required or something like that, then possibly an urgent court application would be required with regard to that medical treatment or to confer parental responsibility, potentially.
Okay, let's switch now to Australians, Monica, who are using overseas surrogacy. Given under current law, the foreign surrogate is recognised as the legal parent. Could she come to Australia post-birth and be awarded custody?
I hate to say it, but it's possible. It hasn't happened.
It's never occurred. Right.
Sorry?
It has never occurred.
It has never occurred.
Okay.
There's no legal reported cases where that has occurred. But under our system, it's possible. If the surrogate didn't relinquish the child, or if the surrogate played a very significant role in the life of the child, then arguably they could down the track get a parental responsibility order. So not a parenting order necessarily, but so it does really depend on the circumstances of the case. There's a famous case of Grothendieck's where a donor was declared to be a parent in the Family Law Act pursuant to our legislation, and some of the key things the court looked at in that case was the fact that they were strongly and heavily daily involved with the child. They were providing financial support, ongoing emotional support, and they were acting like a parent. So arguably in that scenario, you know, there's a potential for something like that to happen.
Yeah, okay. Dana, we might switch to you now. In the Ukraine context, how does surrogacy contracts need to be laid out to avoid complications later on?
The most important thing in Ukraine to have the right contracts in place. When starting the contracts, you have to make sure that your contracts with the surrogate will be notarized, because this is the legislation in Ukraine.
By a Ukraine notary? Or?
By Ukraine notary.
And what is a notary? Tell us what notaries are. Are they lawyers or are they?
In Ukraine, they're not lawyers. Here, they're lawyers.
Not always.
Yeah,
No,
it's like an officer of the court that is like a clerk.
Right.
They don't have law school degree.
Okay.
But they have the license to do these verifications.
Yep.
I know that a lot of agencies will tell you not to do that because it's expensive. When you have a notary service, you have to also pay taxes on it. So that's the notary payments, but it includes in that. So this is very important not to cut edges, because when you come to register the child after birth, you would need the contracts, and if the contract is not in the proper way, it will be hard for you to register the child. It will take more time, and after registration, of course, you receive your birth certificate with both parents' name. So
Okay.
not doing it in a proper legal way could contaminate your procedure after birth.
Right. So at birth, who's listed on the Ukraine birth certificate?
Intended parents, regardless of gametes donation.
Okay, so even if the intended mother wasn't the genetic mother, she's listed.
Yes.
Okay.
Same with intended father if he's not connected.
Okay. And does Ukraine also grant legal parentage to that Australian couple? Are they the legal parents under Ukraine law?
We don't need that, because according to the family court legislation and according to the Family Court Act, the child is not the surrogate child. So it's the intended parent's child. So we don't need to have, like in the United States or in Australia, like a parental order, because it is granted as soon as the baby is born.
Okay.
So the baby is the intended parent's baby legally from the time he's born.
Because of the birth certificate or because of...
Because of the law. The family law says specifically, if you transfer an embryo to a third party,
Yep.
that embryo belongs to the intended parents and not to the third party. They call the surrogate a third party.
Got it. Okay. What about Australian citizenship? How does a baby born in Ukraine get Australian citizenship? Because they don't get Ukraine citizenship.
I have now one case of Russian-Israeli, like one is Russian, one is Israeli, and they're not through my agency. They came to me after birth. They weren't aware of the situation that they have to do some legal paperwork in their nationality. So everything is delayed. So we're trying to get Ukrainian passport. That would be like a first time we're trying that, because they're really stuck. But generally speaking, the child is not Ukrainian,
Yep.
and he will get the citizenship of his parents. In your case, it would be Australian citizenship. We will provide all the paperwork, legal paperwork, a birth certificate with 2 apostille, translation, surrogate declaration, embryo transfer report, all what you need to have in order to apply for a citizenship card. That would be around 5 to 7 working days.
Right. And I understand that the government in Australia requires a DNA test, like a mouth swab from the baby.
Exactly.
And that's done by a doctor in Kiev, is that right?
Yes, there is a clinic in Kiev
Yep.
that is related to the embassy.
Yep.
And the parents are doing that after they get confirmation from the High Commission. They get a letter, like a referral letter, and then they do that and they take the kid to the embassy, and the embassy sends it in a diplomatic mail to Canberra.
And do you find most of the genetic parents, do they get their DNA done while they're in Ukraine too, or do they have the DNA done before, while they're back here at home?
I
before
usually
they go?
recommend the intended parents to leave samples here before they leave,
Okay.
and then the baby is taken in Ukraine.
Okay.
It's just easier.
What other legal documents are required to do surrogacy in Ukraine?
Parents need to be heterosexual, married couple, marriage certificate with apostille,
Yeah.
and they need to have their passport valid at least for the year of the process. And they need to have a medical indication letter indicating why they refer to surrogacy. They don't need to have this word on the letter, but they just need some medical history to see if they had more than 4 IVF attempts, or if they had any disease that prevents from the mother carrying or endangers the fetus.
So you mentioned they need to provide their marriage certificate, which is apostilled. How do you get something apostilled?
In your foreign affairs, whoever got married in Australia.
It's a stamp, is it?
Yes, it's an international authentication stamp
Right.
that is given in each country's foreign affairs. So in your case, if you got married in Australia, you receive it from the Australian government,
Right.
foreign affairs.
Okay. Monica, for you, do you ever take on cases where an Australian couple wants to seek some sort of recognition of parentage from overseas surrogacy?
So we have done some cases. It really does depend on whether you need an Australian lawyer, will depend on the country in which you're undertaking the surrogacy arrangement. So we've talked about surrogacy arrangements in Canada and America, for example, where the intended parents are recognised on the birth certificate. So in that situation, whilst you have the option of coming back to Australia and getting a parental responsibility order, you often don't need to do that.
Yeah. And would you tell a client that? You don't need to get that order?
That's right, yeah, absolutely. So we don't want to create work where we don't need to, but certainly it's interesting that I guess what I should say is that a foreign birth certificate does not of itself under Australian law confer parental rights to a couple. So as our law stands, and I think we all agree our law needs significant reform, that doesn't give you effective parental rights in relation to your child. The family court can give you that. It can't give you an effective parental declaration, but it can give you what we call a parental responsibility order, and that is an order that allows you to make decisions about any long-term aspects of your child. And it basically gives you all the rights, powers and responsibilities that other parents have of their biological children. So that's an order that can be obtained through the court. The interesting situation,
How much
I guess,
does that cost, that kind of an order?
it depends. We're going through a lot of changes in our court at the moment. So we have a few judges being appointed who don't have a lot of family law experience. So if we had a judge like that, it could take longer than if we had an experienced judge dealing with the matter. We've had them done within 6 months, and the cost is probably 8 to 10-ish thousand, but it does depend on how many hearings. Okay. So if you were to make an application in the court, the legislation basically says you have to have an affidavit from the surrogate that has to deal with the arrangements leading up to the surrogacy arrangement and then post, and obviously conferring their consent. The issue is, if you come back, we heard from the panel yesterday about some couples that came back from Canada and America who sort of got their citizenship, came back, and things sort of went quite easily from there. That's fine, and most people can operate informally using a birth certificate. They can get Centrelink benefits and they can enrol their child in school and things like that. But if there was to be, for example, a separation between that couple, the intended parents down the track, the surrogacy issue then becomes to the forefront of the family court. So the court would need to be satisfied about the parenting arrangements at the time of the surrogacy to be able to make orders moving forward. So that does make it quite complicated.
Yeah. But if the child has always been in the care of the intending parents, has never had time in the care of the surrogate, surely, based on best interests of the child, the court would award custody to the divorcing parents.
Well, so our Family Law Act in terms of making parenting orders is completely based from the fact that they need to make an order that is in a child's best interest and prevents a child from being placed at risk of harm. So absolutely, even if the surrogate was, for example, in Thailand and had never had anything to do with the child, the court may still want to be satisfied as to the arrangements of the surrogacy. So they still may want information from the surrogate. So that's just something to keep in mind, whether or not you need to or choose to go down the pathway of getting a parental responsibility order. It's probably important to think about at the time of the surrogacy arrangement of getting a statement or a written affidavit from the surrogate that could be relied on down the track if needed.
Okay, that's great advice.
Yeah.
Okay, terrific.
I want to say something in connected to that. I know that commercial surrogacy is not allowed in Australia, but obviously when all of us, beside Canada, if you do it in the US or Ukraine, obviously the government knows it's paid surrogacy. Nobody thinks it's like altruistic. If Monica spoke about the arrangements themselves, in Ukraine, it's very important when you do these arrangements to have a proper contract. Actually, last week, the Australian Embassy in Ukraine, they complimented us on the contracts that we have. It's very important because the embassy sees these contracts, your government sees these contracts. So it's very important the contracts would be in a proper way, protecting both rights and not one-sided. I know some agencies, they draft a simple contract, just what you have to pay, no rights to the surrogates. It's very important that the contracts will emphasize what kind of rights the surrogates hold, and not only the intended parents. And it's very important that the funds for this will be paid directly to the surrogate, so you know she was paid, because sometimes people send these money to agencies and the surrogate does not receive even half of these amounts. And this is like compromising her rights, and sometimes she's left not paid. So for you, it's not only about, okay, let's see what kind of program I can have to get a cheap deal to have a child. It's also to protect her interests, and also when your government is reviewing the contract and they see that no figures are in the contract, nobody knows how much the surrogate is getting paid, and she's like left with nothing at the end. This is also something that might come in question when if any crisis. Again, if everything is okay, like Monica said, everything is okay, so nobody worries about anything. But legal part is very important when things go wrong, because if things go wrong, then you just say, oh, why I didn't do that and didn't do this, and then things could be really, very confusing legally, because surrogacy is very new. And a lot of issues rises. What about my embryos? What about my genetics? What about who is connected to who? I'm as a mother that I received an egg donor. Do I have the same rights? Yeah, maybe if you carry the pregnancy, but it might be different if a surrogate carries it. So it's a lot of legal implication that you have to take into consideration when you're engaging these procedures. And sometimes people just say, oh, everything will be okay, or I'm so frustrated for years of IVF, I'll just take what I have. And it's really a big mistake. And as a lawyer, I can tell you a lot of times people come to me after doing foolish mistakes and just not taking into consideration the right amount of legal paperwork that needs to be done right, and then they regret it. And sometimes it's very hard to do it, and you're so stressed, so you can't even enjoy your baby. That's
good feedback. I've got time probably for one question from the audience before we go to the next session. Anyone got a burning question they want to ask of these guys while we're here?
Can I just make one comment just about what Dana said? That's why we advocate as lawyers to get a surrogacy agreement drafted, because if down the track there is a family law dispute, if there's an issue around getting parenting orders from the court, we rely on that as a key piece of evidence about everyone's intentions and what was planned right from the outset. So that becomes a key document in any dispute.
Yeah, okay. That's great. Thank you so much, guys. That was really useful.
Thank you.
That's great.